Good day, my wonderful and amiable listeners. I bring to you another news. The news headline: Kanu approaches court to enforce fundamental human rights. Demands 25 billion from the federal government. The news in full. The 10th leader of the indigenous people of Biafra will today at the Federal High Court, Umuahia, be opening proceeding on a 25 billion naira suit against the federal government of Nigeria over its illegal extraordinary rendition or forceful expulsion. The matters which comes up before Justice Evelyn Anyadike is filed by the Special Counsel to Mazi Kanu, the indigenous people of Biafra, Alo Ejimako, leading a team of other lawyers. Recall Justice Anyadike recently delivered a ruling in validation a certain of amended electoral law. In a press release signed and issued by Barrister Ejimako and made available online to the press, entitled Nnamdi Kanu Approach Federal High Court, Umuahia to enforce its fundamental human rights against unlawful expulsion. Nnamdi Kanu will be seeking many reliefs, including but not limited to redress on his forceful expulsion, but also an apology from the Buhari government and special and general damages cost of 25 billion naira from the same government. The full text of the release and the summon reads thus: Today, 25th March 2022, on the behalf of Mazi Nnamdi Kanu, I am leading a team of lawyers at the first hearing of the fundamental rights enforcement suit I had brought before the Umuahia Division on the Federal High Court. The matter lies before Justice Evelyn Anyadike. The suit generis and primarily aimed at redressing the infamous unlawful expulsion or extraordinary rendition of Mazi Nnamdi Kanu, which is a clear violation of its fundamental human rights under Article 12.4 of the African Charter on Human and People's Rights. In addition to the rendition, I am asking the court to redress the myriad violations that came with the rendition, such as the torture and the unlawful detention and the denial of his right to the fair hearing required by law before anybody is expelled from one country to the other. You will recall that on the 19th January 2022, the High Court of Abia State determined the portion of violation of Kanu's fundamental human rights that occurred in 2017. Even as I had made claims that bordered on rendition, the court declined jurisdiction on ground that rendition being related to extradition lies within the exclusive jurisdiction of the Federal High Court. So this instant suit is a result of my considered decision that a fresh action from the Federal High will be the best route towards addressing this matter of rendition or unlawful expulsion and its illegal impact on the prosecutorial powers of the Nigerian state. To be sure, the extraordinary rendition of Mazi Nnamdi Kanu triggered legal injuries that cut across multiple jurisdictions, both inside and outside Nigeria. There are now new legal and even diplomatic issues that must be addressed in the United Kingdom, Kenya, and the United Nations and the African Union. And within Nigeria, the rendition has expanded the matter for beyond the realms of the trial that lies in Abuja. I would like to seize this opportunity to express my profound appreciation to the highly competent and professional team of the lawyers that I am leading in the aggressive prosecution of this complex suit. Special mention must be made of Barrister Patrick Agieze, Owaeto Waze, Mandela Umegoru. The specific relief I request in this suit are as follows. 1. Declaration that the arrest of the applicant in Kenya by the respondent agent without due process of law is arbitrary, and the respondent enforced disappearance of the applicant for 8 days and their refusal to produce the applicant before a Kenya court for the purpose of applicant extraordinary is illegal, unlawful, unconstitutional, and amounts to infringement of applicant's fundamental human rights against arbitrary arrest to his personal liberty and to fair hearing as enshrined and guaranteed under the persistent provision of CFRN and the Charter. 2. A declaration that the detention of applicants is a non-official secret facility in Kenya and the torture of the applicant is in Kenya by the respondent agent is illegal, unlawful, unconstitutional, and amount to infringement of applicants' fundamental human rights against unlawful detention, torture to the fear being to the fair hearing as enshrined and guaranteed under the pertinent provision of CFR and the Charter. 3. A declaration that, pursuant to Article 12(4) of the Charter, the expulsion or extraordinary rendition of the applicant from Kenya to Nigeria by the correspondent without a decision taken in accordance with the law of Kenya is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right to fair hearing, and not to be expelled from the state party to the Charter except by virtue of a decision in accordance with the law, as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. Number 4, a declaration that any criminal prosecution of the applicant, the pursuit of which the respondent unlawfully expelled the applicants from Kenya to Nigeria, is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right to fair hearing as enshrined and guaranteed under the persistent provision of CFRN and the Charter. 5. An order of injunction restraining and prohibiting the respondent from taking any further step in any criminal prosecution of the applicant enabled by the said unlawful expulsion of the applicant from Kenya to Nigeria. 6. An order mandating and compelling the respondent to forthwith restitute or otherwise restore the applicant to his liberty, same being his state of being as of 19 June 2021, and to thereupon repatriate the applicant to his country of lawful domicile, to wit the United Kingdom, to await the outcome of any formal request, and respondent may file before the competent authorities in Britain for the lawful extradition of the applicant to Nigeria. Number 7. An order mandating and compelling the respondent to issue an official letter of apology to the applicant for infringement of his fundamental human rights, and the publication said letter of apology in 3 national dialects. Number 8. An order mandating and compelling the respondent to pay the sum of 25 billion naira to the applicant, being monetary damages claimed to the applicant against the respondent jointly and severally for the physical, mental, emotional, psychological properties and other damages suffered by the applicant as a result of infringement of applicant's fundamental rights by the respondent. It reports that the team leader of the indigenous people of Biafra will today at the Federal High Court Umuahia be opening proceedings on a 25 billion naira suit against the federal government of Nigeria over his illegal extraordinary rendition of forceful expulsion. The matter, which comes up before Justin Evelyn Anadike, is filed by the Special Counsel of Mazi Onyendu Nnamdi Kanu, Aloy Ejimako, leading a team of other lawyers. In a press release signed and issued by Barrister Ejimako and made available online to the press, entitled Nnamdi Kanu approaches Federal High Court Umuahia to enforce his fundamental rights against the unlawful expulsion, Nnamdi Kanu will be seeking many relief, including but not limited to redress his forceful expulsion, but an apology letter from the Buhari government and special and general damages cost of 25 billion naira from the same government.